Historically, the single-family court has operated behind closed doors. For decades, proceedings involving the dissolution of marriages, the division of assets, and the placement of children were strictly shielded from public view. This secrecy is necessitated by the nature of the data handled in these rooms: complex financial disclosures, allegations of domestic abuse, and the immediate welfare of vulnerable children. Because of this sensitivity, practitioners could historically offer their clients a baseline procedural guarantee: absolute anonymity. What happened in the family court stayed in the family court. But that foundational guarantee of absolute privacy is no longer an operational certainty. The shift is driven by a specific procedural mechanism: the Transparency Reporting Pilot. Under this pilot, the family procedural rules actively permit accredited journalists and legal bloggers to not only attend these previously sealed hearings, but to report on them. This is a sharp reversal from the traditional model, where all non-parties were strictly excluded to protect the identities of the families involved. The pilot functions as a formal, systemic test of judicial transparency within the family justice system. It forces a direct, unavoidable collision between two competing human rights at the center of the legal system. To understand this conflict, we have to look at the Human Rights Act 1998, which provides the overarching legislative framework for the pilot. The Act requires UK courts to interpret legislation in a way that is compatible with the European Convention on Human Rights. On one side is Article 6 of the ECHR, mandating the right to a fair and public trial. Opposing this is Article 8, guaranteeing the right to respect for a private and confidential family life. The administration of family law exists precisely where these two competing statutory articles collide. The single-family court is now tasked with continuously balancing public institutional accountability against severe familial confidentiality in real time. Until recently, the default position under the family procedure rules was that financial and child proceedings were held in private. That default privacy has been steadily dismantled through appellate judicial precedent. A critical accelerator in this shift was the Court of Appeal decision in Norman v. Norman in 2017. In that case, the court explicitly refused the wife's application to have the details of her appeal anonymized. The judges reasoned that the necessity of maintaining the principle of open justice outweighed the individual's preference for privacy. Norman established a strict threshold: only truly exceptional circumstances can justify departing from open justice in the appellate courts. This ruling reassigned the legal burden. Practitioners must now actively justify why anonymity is necessary, instead of forcing the media to justify publication. The Transparency Reporting Pilot takes the precedent set in Norman and physically operationalizes it within the single-family court. Exposing the complex mechanics of the family court is deemed necessary to legitimize its authority to the broader public. It does this while placing strict safeguarding boundaries on accredited reporters to prevent unregulated data dumps. The primary advantage is fulfilling the Article 6 mandate, dismantling the stigma that family courts operate as secret tribunals. By allowing media presence, the system opens itself to scrutiny regarding its methods of asset allocation and child welfare determinations. However, systemic critics argue that the pilot severely compromises Article 8 privacy protections. This sensitive financial and personal data is vulnerable to public media exposure. To understand why, look at the bedrock procedural requirement of family financial remedies: absolute, full, frank, and clear disclosure by all parties. The 2010 case of Immerman v. Immerman serves as a historical warning of how illicitly obtained or exposed data can disrupt proceedings. Critics warn of a chilling effect, a scenario where parties withhold vital financial data out of fear it will be published by the press. This fear directly undermines the court's core function. Judges simply cannot rule justly without a complete and accurate factual matrix. It creates a critical paradox. The pursuit of public accountability may actually degrade the factual integrity of the family court's rulings. The pilot operates as a managed stress test of the family procedure rules, seeking a point of equilibrium between disclosure and privacy. To manage this conflict, judges use a specific procedural tool: the Transparency Order. This allows them to restrict the scope of media reporting on a case-by-case basis. The order establishes the precise boundaries of what data can be published and what details must remain strictly anonymized. Drafting the transparency order is the practical, daily realization of balancing Article 6 against Article 8 in the courtroom. The default expectation of anonymity for family law clients has been removed. Practitioners must now proactively anticipate media presence at all stages of their hearings. Lawyers have to prepare rigorous, precedent-backed arguments to secure anonymity on a strictly case-by-case basis. This creates an ethical necessity to advise clients on the specific risks of public exposure before initiating proceedings. Modern family practice requires proficiency in both family law and the complex jurisprudence of media access and human